Have you ever wondered how to make sure your wishes are honored and your loved ones are taken care of long after you are gone? It is a common question that many couples consider as they build a future together. At its core, both a will and a trust are important legal tools designed to help you manage your assets and provide for your family. The primary difference is that a will goes into effect only after you pass away and must go through a court process called probate, while a trust can manage assets during your lifetime and after death, often avoiding probate altogether. Understanding the why behind these differences is key. A will is a foundational estate planning document that declares who inherits your property, names a guardian for minor children, and appoints an executor to carry out your instructions. The reason it must go through probate is to legally validate the will and oversee the distribution of assets, which can be a public, time-consuming, and costly process. A trust, on the other hand, legally transfers your assets into a separate entity managed by a trustee for the benefit of your named beneficiaries. This process happens outside of court, offering more privacy and potentially faster distribution. Deciding between a will and a trust often depends on your specific situation. If you have significant assets, own property in multiple states, or desire more privacy and control over distributions after your passing, a trust might be a more suitable option. For example, a revocable living trust allows you to remain in control of your assets as the grantor and trustee during your lifetime, and it can be changed or canceled at any time. Upon your passing, a successor trustee steps in to manage and distribute the assets according to your instructions, bypassing probate. Conversely, a will is a simpler starting point for many, particularly if your estate is smaller or less complex, or if your primary concern is naming guardians for children. Some helpful terms to know include the grantor, who creates the trust, the trustee, who manages the trust assets, and the beneficiary, who receives the benefits from the trust. For a will, the testator creates the will, and an executor is appointed to administer the estate. One often overlooked benefit of a trust is its ability to provide for incapacity planning, meaning it can designate someone to manage your finances if you become unable to do so during your lifetime, which a standard will cannot do. Ultimately, both wills and trusts offer peace of mind, ensuring your financial legacy is handled according to your wishes. While a will provides a clear directive for after your passing, a trust offers greater flexibility, privacy, and potentially avoids the probate process, allowing for a smoother transition of assets to your loved ones. The best choice is the one that aligns with your family's unique needs and goals for a secure future.